You're ready.
In 12 Angry Men of 1955, one juror prevented a unanimous vote, leading to the eventual switch in opinion of the remaining 11 jurors. Our unit firmly believes in the principle of unanimous decisions and the incorporation of Sixth Amendment jury unanimity to the states in Ramos v. Louisiana of 2020.
Primarily, unanimous decisions ensure a necessary safeguard that accused individuals are only convicted beyond a reasonable doubt. We agree with Michael Shinshini of UC Berkeley that this is critical to the legitimacy in the decision-making of juries. Secondly, unanimous decisions ensure collaboration among jurors. We agree with Justice Stewart's dissent in Apodaca v. Oregon of 1972 that only unanimous decisions protect the right for everyone in the jury to have their voices heard.
Critics claim that unanimity poses issues in practice. However, majority rule would not fix such issues. The Washington and Lee Law Review stated in 1967 that while unanimity leads to hung juries or mistrials in 5% of cases, majority rule poses the very same issue in 3% of cases. Therefore, because there is little difference in the practicality of unanimous and majority decisions, the afforded protections of unanimous decisions make them superior.
We believe that jury trials ensure due process to a moderate extent. On one hand, jury trials are an essential check on the government removing life, liberty, or property without procedural safeguards. Historically, it has been formidable when jury trials are not guaranteed. In 1967, Gary Duncan was denied a jury trial in Louisiana and sentenced without due process. We agree with Duncan v. Louisiana of 1968, which incorporated jury trials to all criminal cases.
That being said, due process is not upheld uniformly. Primarily, although Batson v. Kentucky of 1986 held that racial discrimination must be absent in jury selection, Berkeley law stated that African Americans were underrepresented in juries by 19% as of 2020. This threatens due process, as according to Duke researcher Steve Hartsow, that in 2012, that all white juries were 16% more likely to convict Black defendants than white ones.
Additionally, economic disparities threaten uniform due process. The Department of Justice found in 2000 that defendants with public defenders were 12.5% more likely to be convicted by a jury than those with private defenders. Therefore, reforms such as diversifying juror pools and subsidizing the education of public defenders will strengthen the jury system to ensure due process for all.
Jury trials reinforce a variety of founding principles to a great extent, two of which being limited government and citizen participation. Primarily, in terms of limited government, jury trials check the government's ability to deprive one's liberty. Following America's independence from England, Thomas Jefferson stated in 1789 that trial by jury is the only anchor by which a government can be held to the principles of its constitution. We agree with the National Judicial College of 2020 that this is evident today in the pure structure of a jury of one's peers being given the absolute power to decide verdicts.
Second, in terms of citizen participation, jury trials ensure that citizens play an active role in the justice system. Shortly after the drafting of the Constitution, Luther Martin articulated the importance of citizen participation in juries in Anti-Federalist 83, in which he stated that jury trials are necessary as a means by which the people are led into the knowledge of public affairs.
We see this participation evident today, as the National Center for State Courts stated that 10 million citizens reported for jury service in 2021. The embedded principles of limited government and citizen participation make jury trials a keystone of the democracy intended by the founders. Thank you.
Great, thank you. In most circumstances, jury deliberations are kept secret. We don't know what was said or what went on in the jury room. What are the pros and cons of that policy? Do you think it's a good policy?
Yes, I definitely believe not having cameras in the courtroom is a positive aspect due to the fact that by allowing individuals to get insight into how jury trials may be, will set an unreasonable expectation for individuals when they are to be put on a jury. We see with the CSI effect when it comes to television shows that individuals seem to have this expectation that they need medical DNA evidence when it comes to evidence in jury trials. And by having cameras, it could set that same expectation for juries in the future.
However, I do think that there's an important point to be made that at certain times, having kind of a little bit more of an understanding of what actually goes on in jury deliberation rooms can be beneficial. For example, in 2005, Professor Sherry Diamond of Northwestern Law was granted exclusive access into seeing what happened in jury deliberation rooms, and this led to a very in-depth study of the requirements of unanimity that kind of made more public awareness of how jury deliberations work. And I think that this education is definitely a very crucial aspect as well.
And in addition, we've seen that in Richmond Newspapers v. Virginia of 1940, it was held that trials should be public because they kind of promote education about what goes on in our system. And so I do agree with Lily. I think that having trials be public and having people be able to see what goes on in deliberation could have some benefits in terms of increasing the education about perhaps what jurors talk about, or procedural safeguards, or what occurs in trials themselves. And so I think they do have benefits as well.
What about nullification? Should juries be free to act against instructions if they feel that that's likely to lead to a more just result?
Yes, I think that jury nullification can actually have a positive effect within the jury trials. For example, T.M. Scallion in 1988, in her book, What We Owe to Each Other, she argues that jury nullification itself promotes a sense of individual level for another person and promoting laws that they don't deem just, and just rather promoting something that they believe would be just for someone. And just because a law says something, that doesn't mean it should be the right thing to do.
And to build off of Alicio's point, I definitely do want to echo that sentiment that laws are not always fair. And I think that one person I would look to in terms of this kind of discussion is Paul Butler, who was a former prosecutor in Chicago and is now a professor at Georgetown Law. And he stated that in his time as a prosecutor, he saw that a number of juries would kind of nullify charges for nonviolent drug offenses, and that led to more legislative change within his community. And I think that jury nullification definitely plays a very crucial role in ensuring that the government isn't kind of the sole arbitrator of the law.
However, on the other hand, I think jury nullification can be really dangerous. I think giving jurors the right to decide and have more power in cases can be disastrous. We've seen in the Jim Crow era, in the case of Emmett Till of 1955, he was a young Black man who was lynched by a mob of white men, and an all-white jury acquitted him because they kind of ignored evidence. And so I think the fact that this exists in our system today is super dangerous, because if it can have dangerous effects like this, I don't believe it should be used.
Let me, if I may, go to the beginning of the jury process. The jury pool, what can be done to ensure that the veneer is representative of the jury of one's peers for the defendant? Are there things you can think of that could be done to ensure this?
Yes, that's a great question. So we have looked into several proposals of how we can improve the jury pool and make it more representative, starting off with focusing on our lower socioeconomic background individuals. We do see that it's very difficult for them to attend jury duty due to the fact that the pay, specifically in our state of California, is only $15 per day, which makes it very difficult for individuals who hold lower class jobs, who need to have the pay to survive on a daily basis, which is why we look to Australia, in which they've implemented a system where there's a different pay based off of each state of jury duty. And this will allow for more individuals to come and attend jury duty and be a part of that jury pool, so we could have a more representative pool for our defendants.
And in addition, I would also like to propose having possibly ex-convicts participate within the jury pool or even be considered. For example, we now see in our California Senate Bill 310 that now we can consider ex-convicts part of the jury pool selection. And even in Maine, they consider that it's necessary or even beneficial because it serves as rehabilitation for ex-convicts. Though I want to stress that not all ex-convicts should participate in the jury. For example, ex-convicts that probably have any sort of sexual offense or any sexual harassment, we do not agree with those.
And in addition, we can kind of take more of a procedural way. We've seen Chief Justice Hood of the Eastern District Court of Michigan in 2019 try to conduct more frequent address checks when they are sending out jury summons to kind of increase their jury pool. And in only the few months that they have kind of tracked this, their jury summons response rate increased from 3% to 10%. And so I think this is such a great way that we can try to increase the jury pools to be more accurate and more diverse and include members of the community to be a true representation of a community of one's peers.
Oh, how about civil cases? Should unanimity be required in civil jurors? Why not?
I think that when asking this question, it is important to note that as of now, there's kind of no uniform precedent because the Seventh Amendment civil trial by jury has not yet been incorporated to the states. But I personally do believe that in civil cases where there is a jury, there should be unanimity, specifically in civil cases that kind of have to do with personal necessities such as welfare or healthcare benefits or things of that nature. However, in our own state of California, we do see in Article 1, Section 16 of our Constitution that they only require a 3/4 majority for civil cases, and this is not something that we would agree with.
Yeah, I always like to bring up Alexander Hamilton. He also stated that if we needed a constitution, the right to a jury within the civil cases, he mentioned this in Federalist 83. And I think it would be beneficial to have a uniform federally mandate for having unanimous juries, as my colleague Lily said, for human necessities.
Which is why we would agree with Cornell Law School, in which they stated that even one less person than unanimous makes such a huge impact on deliberation, which is why when focusing on unanimous decisions, whether it be in civil cases or criminal cases, it's essential that we have all members agree on the basis of the conviction, because even one individual who does not agree can have such a large impact on a defendant's future or further methods of trial.
I wanted to shift back to the criminal context. We talked a lot about the importance of juries, but most criminal cases never see a jury. Do you think plea bargaining has really undermined the role of the jury in our system? And are there changes you might suggest?
Absolutely, that's a great question. So plea bargains today in our system play a huge role. According to the Innocence Project of 2018, in the past 50 years, 97% of cases went to plea bargains. And so only 3% of those cases went to trial by jury. And I personally believe that according to the statistic, due process is in a great threat because of this, because due process is guaranteed through our jury system by having a jury, by having this process to have your case be heard. And so to have plea bargains take 97% of those cases, I think is a huge infringement.
And kind of one of the main reasons that we do disagree with plea bargains to this extent is that we think that it violates the unconstitutional conditions doctrine as outlined by Frost and Frost Trucking Company v. Railroad Commission of 1926, in which this case stated that the government compelling the surrender of a right for any kind of additional benefits violates the Constitution. And so we do not think that plea bargains should be upheld to this extent, even though Brady v. US of 1970 stated that they play an important role within our system.
And one solution that we would like to propose is Philadelphia has a system of bench trials against plea bargainings, and the Atlantic reported that apparently 75% of the convicts end up taking the plea rather than the 97% that it's taken federally wise. So I believe that having bench trials will be beneficial because you also have the right to counsel.
How does that work, though? So can you tell me a little bit more about the Philadelphia system?
Yeah, so within the Philadelphia system, essentially, they're providing, it's more widely available to have a bench trial rather than just taking the plea. And they'll guarantee counsel for you instead of just taking the plea within it. So it really is beneficial for due process protections as well.
So is that time?
Yes, that is it. Yeah.
Okay, all right. Well, let me give a round of applause here.
Thank you.
Kind of missed the applause. You guys would get thunderous applause if there were actually, we weren't in the matrix here.
Right.
Yes.
Yeah, so we'll give a little bit of feedback. It was nice to talk to you about this question again. I mean, you can't see my page, but there's barely any white on it. I was writing down so much, and apologize to your friends and family, because it's clear that you've been doing nothing but reading for the past 6 months, and you probably neglected every other aspect of your life. But seriously, the number of studies and law review articles and other supporting evidence you cited was really impressive. And it wasn't that you were just throwing, authorities at us, right? It was authorities that were actually relevant to whatever point you were trying to make, and you were able to talk about what those authorities actually said. So that was really good. I thought our discussion on the jury pool in particular, about how to improve that, I thought that was just a really full and just really excellent answer. On my initial question about jury secrecy, I think we got a little bit off on the wrong track. I was focused more on deliberations within the jury room, not necessarily the publicity or the public access to the trial itself. But Lily, you came in and kind of refocused the answer on the question. And so I thought ultimately we got there, but just be careful to always listen to the questions. There was another time where one of you, it was a 2-part question, and one of you, I think it was Alicio, made sure to come in at the end and say, and to answer the second part, here you go. And so that shows that you're a strong We the People unit. You're listening to each other, you're listening to the judges, and are really ensuring that the questions get the full treatment. So nice job overall, and good luck in the competition.
Thank you.
Thank you.
Yes, well done. I think you demonstrated that not just the level of preparation, but why you were here Monday afternoon. I do appreciate the depth of the coverage, as was stated by Judge Glickman. I also appreciate some of the information you shared with us, which was quite enlightening regarding Australia and what they do. I'm surprised that California, $15 a day, first day, and it continues throughout the entire time. They don't increase on subsequent days. Other states do increase on second and subsequent days. So certainly that's some solution you can advocate. The whole notion of Philadelphia trying to encourage bench trials certainly adds to the caseload for judges, but certainly fosters justice within the system. You have certainly done well and excelled. I congratulate you. I wish you well in your endeavors, and be the change makers that I think you can be. Thank you.
Thank you so much.
So yeah, so I I agree. I have sort of superlatives to sort of say. I will say, I thought after a weekend of listening to very smart high school students, and then particularly a day of listening to really smart high school students, that I knew everything. But I must say, we got to the next to last argument, and I don't think I knew that the 7th Amendment was had not been incorporated. So that was a really nice fact. It was germane. It wasn't just, you just weren't showing me how smart you were. You actually, it was actually relevant to sort of what the question was. So, nicely done. I thought we were going to be able to sort of totally lead you down the primrose path on nullification, but I think Shristi, no, who was it who came in at the end there? I guess that
was me.
Yeah, okay, Sasha, you came in at the end and said, "Oh, not so fast." Here are the problems with it, which is important. I think that's a really, at the end of the day, no matter sort of how much in a particular case we might sort of appreciate nullification, ultimately it's lawless mob rule, and not something that we really should be encouraging. And Alicio, I really like sort of the reference to Philadelphia. Really, all of you, the level of participation among the panel was, I think, among the best we've seen. So I don't suppose you guys, have you been spending a lot of time with each other by any chance?
Just a bit.
All the time.
Good.
Yeah.
Good. Well, it shows. So congratulations to you. Kudos to your teacher and to your parents. My goodness, they must be so proud of you guys with good reason. So congratulations and good luck.
Thank you so
Thank you
much.
so
Thank you
much.
for being here.
Thank you so much. And thank you, judges. Judges, I'm opening up your breakout room.